Can you need drum roll?
That's okay. Alright. So, small party band here. I feel bad because this is, I think, in of all the events that we've had this year, this is the topic that I'm arguably most interested in hearing on. Josh wrote this. So Josh Blackman, professor of law at South Texas Law School, College of Law. Graduated from George Mason Law School, which is, most of our speakers actually are coming from George Mason Law School, so you actually had the advantage of
learning a real constitution.
Exactly. And Josh is an example of like what can happen when you get a real legal education. Has a great blog, joshblackman.com, founder of Fantasy SCOTUS, which is worth your time, and fun. Author of Unprecedented, currently out. The next one coming is Unraveled. And if he sticks it out,
Undone.
Exactly. The Obamacare trilogy. And then, the only other thing that I'll say, I asked a common friend of ours to describe Josh, and this is what he said. He said, a dynamo of ideas, mentioned the planned trilogy of Obamacares, and influential thinkers on the right, according to Alinda Greenhouse Scarepiece. So
she did mean it in a nice way.
What did she say again?
I'm an increasingly influential segment of the conservative elite.
Take that. Exactly. But the thing that really got this sort of started as an idea for wanting to hear from Josh on this is Josh and Randy Barnett at Georgetown wrote a piece that appeared in the Weekly Standard about a month ago, thereabouts. And it was, starting the hard and necessary task of actually thinking through what is entailed in selecting good Supreme Court picks, because for some reason, Republican nominations tend to be a little bit less reliable. I mean, the Democrats are batting 1,000 at this point, pretty much. Have they ever had?
They're actually batting over 1,000. They're actually getting more hits in that bat, amazingly.
Amazingly, that's exactly right. That's perfect, right? And so, and everyone has a different angle on what the problem is, and there's been a big conversation about, judicial restraint versus judicial, activism and original, is it judicial activism to take a strongly originalist perspective to the Constitution? These are important questions because with any luck, we'll have the opportunity not just to make some Supreme Court picks, but honestly, the same principles apply. I mean, the one thing you can kind of say for the George W. Bush years is he did a pretty good job on the courts.
The ones that precedent block.
Exactly. So, this is an important conversation. Josh and Randy wrote this piece. Ed Whalen had some quibbles here and there.
I like it.
I like it too. I love it. He was our first speaker, He was our very first speaker.
They let him into New Jersey? They don't stop him at the border?
No.
But he's not fine.
But he made cracks about our history of, there was the Morristown Library case. That was the, homeless rights.
Oh!
Right?
Yeah, with Judge Sorokin, right? Judge Sorokin.
So anyhow, I'm turning now this from like a fairly slapdash introduction to a long introduction, which is the one thing I was supposed to do. So, John.
You did the one thing I said not to do. Good job, ladies. Well, hello, I welcome everyone. My dad was here, which is always a treat. So, we have a very important task facing us if a Republican wins the White House. How do we pick the next Supreme Court justice, right? How do we choose who will be the next person to take the oath of office, okay? So what happens? We have many old justices. Justice Ginsburg will be 83, Justice Scalia will be 83, Justice Kennedy will be 81, and even Justice Breyer will be 78. And Justice Breyer is known to ride his bicycle. He often gets injured on it, so he's not the safest bet. There's actually the green bag bobblehead of Justice Breyer on his bicycle. He's had a string of bad luck. In fact, when he first interviewed with President Clinton to be nominated. He had broken his arm, and Clinton's like, "Who's the guy with the broken arm?" It did not go well for him. So Republicans have had a problem of making Supreme Court appointments. And going back to the Warren Court, Earl Warren was a Republican. William Brennan was from New Jersey. Actually, as I was driving here, I passed by William Brennan State Park. William Brennan was appointed by President Eisenhower. I think President Eisenhower said it was the worst damn fool mistake he'd ever made in his life. Moving on to the Burger Court, right? Or sorry, the Rehnquist Court. Justice Stevens was a Republican appointment. Justice Souter was a Republican appointment. Justice O'Connor was a Republican appointment. Even moving on, we have the Roberts Court, right? Even Chief Justice Roberts, supposed to be the most reliable vote for the right, has broken my heart with a battered spouse on several occasions. I keep going back to him. So, over the last 7 presidencies, 16 justices have been appointed to the court. Okay? If we go on a purely left-right, blue-red basis, they've had 4 appointments. We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We've had 12. We've had basically a supermajority of the Supreme Court appointed. Now, I want you to pay very close attention. Even though we've had 12 appointments, this is what it actually looks like. We'll do that again, see if you see the jump, right? They've had Justices Blackmun, no relation, Justice Stevens, and Justice Souter, who become effectively very consistent liberal votes. They've had Justices Powell, O'Connor, and Kennedy on the middle, somewhere in the fence, depending on what the given issue is, right? I put a question mark there because some of it's to be determined what the chief ends up doing. But the fact of the matter is, Republicans simply haven't been able to appoint justices who have stuck to the reasons why they were appointed. So that compelled Randy Barnett and I to write an article in the Weekly Standard last month, focusing on 5 lessons, a guide, if you will, of how the next justice should be appointed. And these 5 lessons are aimed at learning from our mistakes and trying not to do them again. Okay? So I'm going to go through these, and I want this to be interactive because we have a nice, cozy audience here. So the number 1 lesson, right, is that a bruising confirmation battle is worth the fight. And I think what we've seen in the past is that presidents were not willing to fight because they had other priorities. The lesson we teach is that nothing is more important for a president than Supreme Court justice. The most enduring legacy of George H.W. Bush is Clarence Thomas. Any of his other policies we don't think about anymore. The most enduring legacy of Ronald Reagan today is Antonin Scalia. These are things that on a daily basis remind us of the president long after they're gone. So we start, of course, with this man. This is President Reagan introducing a judge by the name of Robert Bork. I'm sure you will recall this. There's always the press conference, and then the cheesy shot where the nominee's sitting in the in the White House in the Oval Office just chatting up. When President Reagan appointed Robert Bork, he had to have known that this was going to be a serious, contentious issue. He replaced Lewis Powell, who was a moderate, kind of a swing judge. And he should have known that the left would come out for Robert Bork with guns blazing. So at Bork's hearing, the Democrats spared no mercy. Senator Ted Kennedy very famously had this speech. You can find on YouTube how if Robert Bork is appointed, there will only be back alley abortions and all these pejoratives saying that Robert Bork would be this horrible justice. So, thank you. Yeah, that if Robert Bork was in charge, you'd have separated lunch counters, which is of course all absurd. But the Democrats at least then realized the significance of putting another conservative on the bench and tilting that 5 position the other way. Okay? President Reagan withdrew Bork. And that decision set in motion things which are implausible. So shortly after Bork withdrew, President Reagan nominated another judge, a guy named Douglas Ginsburg. Douglas Ginsburg was actually a professor at George Mason. I love the reason why he was a professor. Okay? Shortly after his obligatory shot with President Reagan in the Oval Office, Nina Totenberg reported that Douglas Ginsburg smoked marijuana with his students. Now, the year 1988 is not the year, sorry, 1987 is not the year 2015. Back then, smoking drugs was apparently a big deal. And for Bill Bennett, Just Say No, Nancy Reagan, Doug Ginsburg, who was a brilliant judge, and I'm not just saying because I was a student, but a brilliant judge, had to go and withdraw his nomination. So the Democrats, in the span of like a month, killed 2 Republican nominations. The sequence set in motion the nomination of a moderate conservative from Sacramento by the name of Anthony Michael Kennedy. You can see Ed Meese and others standing to the right of Justice Kennedy. He was viewed as someone who would be able to sail through the confirmation hearing. Okay? And here's Kennedy's obligatory shot with President Reagan. And when Senators Kennedy and Senator Biden, who chaired the Judiciary Committee, learned about it, like, awesome, right? Lawrence Tribe, he who shall not be named, right? Lawrence Tribe, the famous Harvard law professor, said Kennedy is a good guy. In fact, Tribe is actually writing now that he knew that Kennedy would vote for gay marriage. He said that Kennedy would be great. He knew that Kennedy would be great on gay rights, that he would reverse a decision of Bowers v. Carter. So Justice Kennedy's confirmation hearing in 1987, December of 87, was smooth sailing. He went straight through. And here he is being sworn in. This all started with Robert Bork, and the fact that the Republicans nominated someone and they didn't fight for him. I can't know why, but Judge Bork was qualified to be a justice. I mean, I would agree with him on a lot of issues. I would agree with Justice Kennedy, who's qualified. The Republicans did not vote after him, unfortunately. And recently, Leonard Leo gave a talk where he was discussing this issue. He said, I wonder what happened if they actually went to bat for Bork. They didn't pull him, they actually went and said, go, have a vote. Would he get to 51? That's all we need. We need 51 votes. Or actually 50 if Vice President Bush could cast the vote. Okay? This guy retired. The native son of New Jersey, William Brennan. The choice fell to President George H.W. Bush to replace William Brennan, the liberal line, right? Joe Biden and Ted Kennedy realized that this was a very momentous pick, that much more than Powell, by George H.W. Bush replacing someone as a match with William Brennan would be significant. President George H.W. Bush was influenced by a guy named John Sununu. This was his chief of staff, who was a gentleman from New Hampshire. And they were actually faced with a choice. In fact, Ted Cruz has relayed this story many times recently. One possible candidate was a woman named Edith Jones. She was a Court of Appeals judge in Houston, Texas. And Judge Jones had a pretty solid record of being a notable conservative, very outspoken. She's a friend, but she's quite outspoken. She will not correct me if I say that. So instead, John Sununu said, we can't have another Robert Bork hearing. Mr. President, you have other legislative priorities. Over there with me now. You have these priorities. You cannot waste capital on trying to fight for a Supreme Court nomination. Even though the Republicans held the Senate, they did. He said, you need to go stealth, right? You need to pick someone who will not step off the fight. And this is actually Senator Warren Rudman, who was a senator from New Hampshire, and a young David Hackett Souter, who at the time was a justice on the New Hampshire Supreme Court, and then was briefly appointed to the First Circuit Court of Appeals in Boston. So President Bush, with the smiling Boyd and Gray and Senator Rudman, nominates David Souter. What the heck do we know about David Souter? Do we know anything about David Souter? Not really. And indeed, the cover of Time magazine, when those magazines were so relevant, I think aptly summarized the issue. Who is David Souter, right? Who is this guy? What do we know about him? Surprisingly, Biden and Kennedy were very happy with this nomination. They didn't really fight it too hard. If you think about it, the impact of Joe Biden is not vice president. His decision to keep Robert Bork off the Supreme Court and his intimidation keeping Edith Jones off the Supreme Court changed history in ways we can't even calculate. So Biden, for all his failings, by the way, you know Joe Biden graduated second from the bottom in his class at Syracuse Law School? Second from the bottom.
I totally saw a video where he was talking about how he was in the top.
He graduated second from the bottom. And he also plagiarized his law school note. So he was almost thrown out of school. But, you know, good old Joe, right? About a year later, George H.W. Bush was faced with another choice. He had to replace the retiring Thurgood Marshall, the first African-American appointed to the Supreme Court. Was he willing to have a fight over a nominee? And it's actually unclear if Bush was willing to have a fight. He got one, but he didn't know if he was going to have one. He nominated a man named Clarence Thomas. Clarence Thomas had served for many years as the Commissioner of the Equal Employment Opportunity Commission. He had been briefly for about 5 minutes a Court of Appeals judge in the District of Columbia, but for whatever reason, HW decided to appoint Thomas to the Supreme Court. The Thomas confirmation hearing started off amicably enough. Here's Joe Biden and Thomas. And interestingly enough, initially, the fight over Thomas reflected his views on the law, right? Not in the merits. Indeed, at one point, Joe Biden said, anyone who reads a book by Richard Epstein has no place in the Supreme Court. Yeah, he said that. I had lunch with Richard today, and he was bragging, saying, yeah, Biden wanted to come testify. I was never going to get set up by him. And effectively, Biden tried to portray Judge Thomas as this right-wing zealot who would apply law and actually think what the Constitution meant to its framers, God forbid, right? But then the other shoe dropped, and I'm sure we all remember Ms. Anita Hill. It was at this point that the nomination almost went off the rails. Anita Hill alleged that Clarence Thomas sexually harassed her at the EOC, that he gave her a can of Diet Pepsi with a pubic hair in it. Remember these stories. And effectively, people thought maybe he would not make it through. Eventually, Thomas came up for a vote, and he was narrowly confirmed. But the Republicans were not ready for that sort of fight. Now, this is a picture that was filmed in 2010 after Justice Sotomayor was confirmed. And I wonder if Mr. Thomas and Mr. Biden, where is he? There he is. If they had any words for each other, hopefully they left that one behind them. We fast forward to the next major choice. Okay, after the retirement of Justice O'Connor from the Supreme Court, you'll recall that initially President Bush nominated John Roberts to replace retiring Justice O'Connor. Then Chief Justice Rehnquist, unexpectedly, but he was quite ill, passed away. So President Bush switched it. He said, okay, John Roberts will become the chief, and who do I fill in Justice O'Connor's seat? And he picked this lady. Her name was Harriet Miers. She was a White House counsel and had worked in the Bush White House for a number of years. She was a very trusted and loyal advisor. PowerPoint crash. That's a new one. That's sad. I keep talking about Harriet Miers. So effectively, the president appointed his White House counsel to replace Justice O'Connor. The problem was that Harriet Miers really had no record of being a person who thought about constitutional law. She was a corporate attorney. She did corporate law in Dallas. And she frankly had no record of making these sorts of decisions. Why did Bush pick Harriet Miers? The reasons are unclear, but in Jan Crawford's book, Supreme Conflict, she discusses how Bush thought that she would be an easy nomination. That Bush did not want to have to go through a bruising confirmation battle. Myers. Okay, there we go. There we go. So Harriet Miers is indeed smiling here, but she would not be smiling for long, because within moments was a conservative coup. Ann Coulter, among others, Randy Barnett, and the liberal in the academy said, "Why are we doing this?" Okay? The number one sign that this pick was wrong was that she was endorsed by Chuck Schumer and Harry Reid. When Chuck Schumer and Harry Reid endorse a Supreme Court Republican nominee, you're doing something wrong. And indeed, Harriet Miers' visits to Capitol Hill did not go very well, because people basically said, you're not qualified to be a justice. In fact, Slade had this handy-dandy, her chance of confirmation. And as the days and weeks went by, this went, Slade.
That's really funny.
Yeah. So here, indeed, we had a Republican battle, and it wasn't Democrats fighting those Republicans. Fortunately for us, President Bush withdrew Miers' nomination and appointed Justice Samuel Alito, a native son of Trenton. So he's a judge from your backyard. The Federalist Society held a conference in Dallas at the George Bush Library a few weeks ago, Harriet Myers was there, as was Sam Alito. Word. Right. But it worked out okay. So what does this mean going forward? So one thing which we have to keep in mind, the magic number for Supreme Court justices is not 60. The number is 51. And the reason why is because of the nuclear option. Let me explain. Traditionally, the Constitution only requires the advice and consent of 51 votes in the Senate to appoint a judge, right? But for at least the last, several decades, a filibuster was impossible. Now, you don't have to get like Mr. Smith goes to Washington. It's sufficient just to basically block what's called cloture, so you need 60 votes. This was used throughout the Bush administration to block President Bush's judges. And during the Obama administration, Republicans started using the same filibuster. Until Harry Reid triggered the so-called nuclear option. What does that mean? Harry Reid said for all lower court appointments, we no longer need 60, we only need 51. Harry Reid specifically said this does not apply to the Supreme Court. I don't care. The second this Supreme Court nomination, it will be dissolved. So effectively, by triggering the filibuster, we now have 51 vote threshold, not 60. Okay? Why is that relevant? We don't need to appeal to as many people anymore. We can get 51 and be done with it. Okay? There's a little bit of irony and hypocrisy because the Republicans consider the nuclear option, and the Democrats opposed it. And then when the roles were flipped, the Democrats favored the nuclear option, Republicans opposed it. But now it is gone. All you need is advice and consent. And Harry Reid done blown that up. And if there's a Republican president, it very well may come back to haunt the Democrats. Now, you say, John, 51 votes, right? What happens if the Democrats control the Senate? What happens if the Democrats filibuster any nominee from President Rubio, for example, right? Well, who says you have to fill the seat right away? As Clint Eastwood said, and the chair. And I don't say this point lightly, but compromising because you can't get someone confirmed in 2016 or 2017, you deal with that person for 30 years. If the Republicans are certain they'll take the Senate back in 2018, which I actually looked at the numbers, the Republicans are likely to lose the Senate in 2016. They have so many seats to defend. We will likely gain it back in 2018. So say Justice Ginsburg, something happens to her in 2017, and the Democrats block everyone, okay, let them deal with 8 justices for a year. Or make a recess appointment for a year. I don't know if it's that big of an urgent issue. But don't give them a lifetime appointment as a compromise. No more Robert Bork situation, no more Doug Ginsburg, no more David Souter, no more Harriet Myers. Get this right. And if you can't appoint someone, wait till the Senate opens up. And if the Republicans don't control the Senate, then you go to Plan B. But do not start with the supposition that you need to compromise. This is one thing which, frankly, you cannot compromise on because it's such a lasting influence. Okay. The second lesson is one which may be somewhat counterintuitive, and it's that we should favor justices with a paper trail. Okay? Often it's said we don't want judges with a paper trail, right? We want judges who are a kind of blank slate, right? That they'll sail through confirmation hearings, that nothing wrong. This is bad for a host of reasons. Okay? One of which is this idea of trimming your sails, and it's a counterintuitive notion. But believe it or not, there are a lot of people who really want to be judges. Not in this room, of course, but there are a lot of people who really want to be judges. And they want to be judges so bad that they avoid taking positions on controversial issues. This is very, very dangerous. These are the last people who want on the bench because they lack the intestinal fortitude to make tough decisions. If you're always trying to placate others and make people happy, you are not true to yourself, and you will be driven by other people's agendas. For example, the Chief Justice, even though he had been a Republican lawyer for decades, had never spoken out on his own issues. He had never given a single speech saying, here's my vision of the Constitution. Here's how I think the law should work. It was always, well, here's what my client says, or oh, here's what Attorney General Meese would want me to do. Indeed, there was this cartoon that came out, which was oddly prescient for the wrong reasons. It says, not much of a record for us to shoot at, but look at the size of that right wing, right? And here the Democrats shooting at this stealth-bomber. This was the exact reason why people like John Roberts said, don't worry, we know this guy, right? We know him. He's one of us. And I think he has other priorities. I would also lump Justice Elena Kagan in a similar category. I mean, she had been an academic for a number of years. She wrote 6 articles. I've written more this year than she wrote her entire career. I'm not saying that to brag. She just never wrote anything. Now, Professor Epstein claims that she just wasn't a very productive scholar. Compared to Richard, no one is. But I will say, I think she avoided writing anything controversial. She just didn't say anything to upset the apple cart. And indeed, a very similar cartoon, the same person, what was drawn is stealth fighter, stealth bomber, stealth nominee. With the Republicans saying, look, she's on the paper trail, right? These are the last people in the world to put in court. Now, there was a great article published about 10 years ago. The title of the article was The Little Supremes, okay? The thrust of the article is like this. They're an entire group of people who were so committed to the federal judges that they lived their lives in fear of making controversial statements. They lived their lives always saying, okay, let me not put this out because maybe this may disqualify me from federal office later, right? The Little Supremes. These are the last people in the world we want to bench. I always include this picture of Justice Kagan from our high school yearbook holding a gavel and wearing a robe, and she had a Felix Frankfurter quote in her high school yearbook. I didn't know who Felix Frankfurter was, so I got to law school. And then for your Princeton boys, just Alito had a little bit comical, but he said, Sam intends to go to law school and eventually to warm a seat in the Supreme Court. So this was in Sam Alito's Princeton yearbook. Now, there was a quote from Pam Carlin, who's a prominent liberal professor at Stanford, but very articulate about a fan of hers. And she basically was asked, you know, you're very outspoken in a number of issues. You were not appointed by President Obama to the Ninth Circuit. Do you regret it? And what she said? Absolutely not. I would not change a damn thing. I will live my life as I want to live my life. I will say what I want to say. I will change the law through the means I have and not trim my sails in one day hoping that I can get the Supreme Court. And people with this sort of intestinal fortitude need to enter the court who can withstand and say, I don't care what Lindsey Greenhouse writes about me, right? I don't give a damn what she writes about me, right? I don't care what, you know, Nina Tiltenberg says about me in NPR, right? This is what we need. This town, as it were, it's a great book about the morass that is the DC swamp, which maybe L'Enfant should have never drained in the first place, right? It's a very dirty place. And indeed, you recall after NFD was decided that people like Glenn Beckman charged the Chief Justice was a coward, that he caved to the pressure, that he changed the vote. And I gave a talk on this thing last year at the Obamacare decision, but this is a serious concern to have. Chief Justice Roberts often says, you know, I want to be like, I want to be like John Marshall, the great Chief Justice, right? I want my judges to be like James Madison, right? I want my judges to be like Madison and think, how do I find what the framers thought? Not how do I twist and turn the Constitution to try and reach a result that's politically salient. John Marshall should not be emulated. His decisions were mostly wrong. He should not have been in Marbury versus Madison. He should have recused. These are bad judges, right? We should not be emulating John Marshall. And the Chief Justice worships him. I think is a mistake. Right? So what else? What's another lesson? So for generations, we've been taught that judges should not be activists. We should not have judicial activists. We need to have, you know, the judges need to be restrained. I think that the Obamacare decision, more than anything else, has taught us that this is not a good lesson to follow. Because the Chief Justice's decision illustrates what is and is not judicial activism. So I like to compare the two votes of the Bush nominees, Sam Alito and John Roberts. Justice Alito voted to invalidate the entirety of the Affordable Care Act. Okay, was this an act of judicial activism? I would argue not. He said, Congress has not the power to compel people to buy insurance. This law is unconstitutional. What did the Chief Justice hold instead? He said, well, you know, Congress didn't call it a tax, but we can treat it as a tax, but it's not a tax for the Anti-Injunction Act, but it is tax enough for us to uphold it. In other words, the Chief Justice said, this law is unconstitutional, but I will apply saving construction. In other words, we'll shred the document up, okay? This is not calling balls and strikes. This is an act of hubris to actually rewrite a law that Congress never enacted to save it. This is not humility, and it's important to recognize that. So if we're not focusing, right? If we're not focusing on, you know, these cliched responsive restraint activism, you know, what are we actually looking at, right? We should be looking at judges who focus on big issues, okay, frameworks, because it's impossible for a president to know in advance what sort of case will come down the pike. And the example I like to use is this. If I had told you in 2009, when President Obama was inaugurated, that the signature case of his administration would involve a mandate to force people to buy health insurance, crazy, the Supreme Court won't resolve that. If I had told you in 2000 that the defining issue of the Bush administration would be whether the president can lock people up in Guantanamo with Cuba, would say, "Are you nuts? That's not going to happen." If I had told you in 1999 that the presidential election in 2000 was decided by the Supreme Court decision, are you crazy? We don't know what the next big constitutional crisis will be. We are not capable of doing that. We don't have the foresight, right? Hayek, we don't have enough knowledge to anticipate what judges will confront. The entirety of a litmus test of how they resolve a given issue is stupid, right? Enough with this abortion litmus test. Enough with the gay marriage litmus test. No Citizens United litmus test. We need judges with a framework of what we might call constitutional originalism, or a framework of what the people at IJ, my friend Clark Neely, calls engagement. We need to have judicial engagement where they say, we will confront the Constitution wherever it leads. This is not an act of restraint. Okay? And the final lesson that I want to discuss before opening up for Q&A is how do we actually ferret this out? Now, during the Supreme Court confirmation of Sonia Sotomayor, she was asked a question about the District of Columbia v. Heller. This was a Second Amendment case. And the question was, Judge Sotomayor, do you agree with the case of District of Columbia v. Heller? And her answer was very typical. She said, it is settled law. It is settled law. What the heck does that mean, it is settled law? Well, you can't ask the judge how we rule in a specific case, because then they have to recuse. So the answer to that will just say, well, that's settled law. Okay, the case at that point was like 2 years old, it's settled law. Okay. 1 year later, Justice Sotomayor was in a case called McDonald v. City of Chicago, which considered the exact same issue as the Heller. Can Chicago ban the possession of handguns? Did Justice Sotomayor adhere to that settled law? Of course not. Barely a year after she testified, she changed her position and said, you know what? I don't agree with Heller. Yeah, I think Heller was wrong. So asking a judge, what do you think about this case? What do you think about this case is stupid. It does not get the answer. But what if you ask Justice Sotomayor, what's your understanding of the original meaning of the Second Amendment? Whoa, right? She can't dump that one. Settled law doesn't explain how James Madison is true to the Second Amendment. Justice Sotomayor, how did the framers understand the Takings Clause? What is the original meaning of the Privileges or Immunities Clause, right? How did the framers understand the separation of powers? If you start framing questions in terms of clauses and not cases, it becomes much harder to dump. Also, I think it would reveal a stunning ignorance of many of these judicial candidates about what the Constitution actually meant in 1787. People like George Washington were sitting across the street. So by focusing on clauses and not cases, you number one, force the judges to actually focus on issues, and second, it'll be much tougher to duck the question. So these are 5 issues that I am taking on the road and hoping that people listen, perhaps beyond the cozy confines of this room, and that we actually have an impactful and meaningful debate on the next Supreme Court justice. We can't afford to screw this up. And I can't say that too lightly, but Bernie Sanders and Hillary Clinton have already said they will pose a litmus test on Citizens United. They will not impose they will only impose a justice if that justice pledges to reverse a case. It's totally unethical. You can't do that. No judge will. But the fact is, they're going to ask. They don't need to ask, right? If you want to become a Hillary Clinton nominee, you know what you need to do. Citizens United will be gone. Heller will be gone. Whatever the court does in Hobby Lobby can be gone. Religious liberty, gone. There's so many issues that can switch. And the Chief Justice, with his long game as he has it, very well may be in dissent for a generation. So we'll stop there, and I welcome your questions. But thank you so much for attention.
I was wondering if you have any suggestions on how to do it would become very apparent is the total ignorance of the senators questioning the judicial nominees on the actual meaning of the Constitution. Because I think even more so than the nominees, they're not going to have the slightest clue what the Constitution is actually about. So do you what would you propose to
So,
tackle
so,
that?
so these questions are not just being asked from the confirmation hearing, right? These are also questions being asked from the private one-on-one meeting with the senators. And to the extent that anyone pays attention to me and others, we will feed them questions of what to ask. The process, though, starts when the president starts making short lists. And there are a series of very ambitious interviews with these candidates. And I hope that whoever the president is asks these sorts of questions from the interviews. No more BS questions about, do you favor judicial restraint? Are you a strict constructionist, right? Should judges follow the law or write laws? These are questions with vapid meanings, right? And I think the lawyers in the White House are smart enough to ask these, but by focusing more on originalism, you may not know how a judge will decide a case. Now, one of the bigger tragedies of the Bush administration was that they did not choose Michael McConnell for a Supreme Court nomination. Michael McConnell is a professor now at Stanford, he was in Chicago, he's been in Utah. He's a brilliant, brilliant man, and such a warm temperament, such a nice person. And for a host of reasons, the Bush administration didn't pick him. Why? He was an independent thinker. They didn't know how he would decide cases. They want someone who would, decide cases the way they want. So I think John Roberts instead. So, focusing someone who's a framework of thinking is such a better approach, right? Because they will be guided by history and not by their own political motivations, as I think John Roberts, as I wrote my book, perhaps was.
Do you think the idea of judicial activism, I have this recollection of President George W. Bush introducing Harriet Miers and sort of leaning forward and saying she's not going to legislate from the bench.
Or do anything else for that matter.
But is that, where did that come from? And has that ever been a useful framework for evaluating anything?
So it's a good question, right? Where did this framework of judicial restraint come from? I think your boy Bill Brennan is partly to blame, your native son, as it were, probably the most influential New Jerseyan ever. Over decades, you got a judge in the Supreme Court making stuff up out of whole cloth. The Warren Court was kind of making up as you go along, color by numbers, right? Paint by numbers. Conservatives said, "Oh my God, we need to stop this. We need to get rid of this activism." But I think they went too far to the direction, and they started thinking, well, even though stuff's not in the Constitution, we can't have judges stepping out of the democratic process. But I think a shift has occurred, and indeed is occurring. Whereas once the democratic process was, shall I say, a little bit more conservative, or passing laws that liberals didn't like, I think we will see in our lifetime, in mine in particular, that changing. And the trend will be towards a more progressive society that has less respect. So I think conservatives will start looking to the courts more and more as a constitutional check against an increasingly democratic and progressive legislature. So conservatives need to be very hasty, very cautious about this rhetoric about judicial activism and restraint, because in many respects, how would Robert Bork have voted in the Obamacare case? Would he have voted to invalidate the mandate? You shake your head no?
No, I'm just saying I'm not no, because I was at a long meeting with Bork many years later. But I have my questions for later.
Okay, I'll officially leave in a second. So I think you're seeing conservatives stop using this, and indeed at this conference in Texas 2 weeks ago, I asked Leonard Leo a question about this, and he said, this line about legislating from the bench is probably not a good line to use anymore. And if you notice in the last debate, Jeb Bush did not use the judicial restraint line. I have a little bit of credit for that because I rigged his campaign over that. But I think candidates can start using the correct rhetoric.
So is it basically that when you saw just complete craziness from Brennan and others, there was just a lack of precision in the argument that was mounted against it at the time? And sort of
we have to stop it. We have
to
stop it. We have to be careful not to overshoot, right? And this is always the concern. If we have too much judicial ambition, that's always also dangerous. Although I'd rather have more engagement than less, because when you have less, we end up, the liberals are going to do what they're going to do. When our guys are quiet, that's when Obamacare happens.
Well, okay. I always want to see what's going to happen in this current session. I'll be very blunt with you. You're brilliant. You got 3 interesting cases coming up. Texas case on who's a citizen who votes. Being an originalist, how is that going to be looked at if you're an originalist? What will happen in the California Union case? And the last one is what the probate judges in Alabama, I don't know whether the court, 'cause I don't follow it that much like you do, have they agreed to look at that issue? The
Okay, so
probate judges are saying we're
I'll take them in reverse order. So the first case you're asking involves the probate judges in Alabama, and this is a case that people frankly do not understand what actually happened. Actually, an article, it's going to be Hastings Constitutional Court in Alabama. So the issue is like this. In Alabama, and in many states, Texas as well, judges, how do I put this? Sorry with this. The Texas Attorney General issued a memorandum shortly before Burger was decided that said like this: we have a Religious Freedom Restoration Act in Texas. Under RFRA, employees get accommodations. So the classic example we say is sugar free burner. If you are a Seventh-day Adventist and the state says that you have to work on a Saturday, that's your Sabbath, and if you can't work, you won't get unemployment benefits. Okay? The Supreme Court said, it was a Brennan decision, that no, they can't do that. That you have to give an accommodation to deal with religious beliefs. So what the Texas Attorney General said in a similar situation in Alabama is, if there's an office of clerks and one employee in that office decides not to give a marriage license to gay couples that goes against religious beliefs, you can give them an accommodation as long as there's no delay, right? So long as there's someone else in the office who can provide the license without any sort of delay, that's fine. I don't have any problem with that. The problem arises only if every single person in the office refuses to provide the licenses, then you have an issue. But in most places, that's simply not the case. So what happened in Kentucky, which is most people don't understand, is that the Kim Davis, the clerk, had effectively said, I don't want any license to be given out with my name on them because it's my authority. So a really simple workaround, what the judge ultimately did was they modified the form. They said this authority is based on the authority of the deputy clerk, not the elected clerk. Fine. This does raise the issue, and it's important to stress that there's a stigmatization that certain gay couples cannot have the same clerk deal with them as everyone else. I mean, no, they're suing. I mean, the ACLU has already filed suit saying that to stigmatize them, they have a different procedure they have to go through. And who knows what to do. The second question you mentioned is the Friedrich's case. This is the union case, which you probably knows more about than I do. It involves public sector employees who are members of the union. Now, if you are a public sector union member, you can't be made to join the union, right? It's basically called an agency fee. This is a fee that's used to cover the bargaining costs, right? Not their activism, their politicking costs, or just the bargaining costs. Ms. Friedrich, she's a public school teacher in California, and she's challenged this as a violation of her First Amendment rights, saying, I don't want to be associated with this union, they're god-awful people. We'll test this later. The case that is at issue is a little Abood, which is a case from the 70s, of whether you can force a public sector union to pay these agency fees. There was a case called Harris v. Quinn and SCIU v. Knox in the last couple of years, where the court seems to suggest that Abood will not abide, that Abood will be struck down at some point. And notably, Justice Kennedy didn't concur, saying, blah, 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 I'm afraid of this, right? So I think there's a decent shot that the court will, in fact, invalidate the overturn Abood. And this would really harm public sector unions because they can no longer collect the agency fees from their non-members. It will become very difficult for them to actually exist because at this point you can free ride, right? You can basically get all the benefits of the union negotiation, not pay for it, which will, they can talk to the benefits. The third case you asked about is Evan Wolf versus Abbott. This is a weird case. So there was a decision called Reynolds v. Sims back in the 60s that said when states are designing districts, they use a principle called one person, one vote. The idea is that if you have a very big district, you can't just, you have to give them more representation. You can't cram all these people into a district and even one representative and have a very sparsely represented district elsewhere, because then you're not divvying it fairly. Okay. Who do we count for purposes of representation? Do we count only voters? Do we count citizens? Do we count every human being? And different states do this differently. But one of the questions here is, can Texas exclude voters? Can they exclude non-citizens, right? So if in Texas, there's a very high non-citizen population, the representation of citizens is actually distorted, right? So imagine if we only considered citizens in Texas, the representation would be much more stronger because there are fewer people in the districts. If we include all these non-citizens, the representation gets weaker. So this case will challenge whether the court will say only people, only citizens, or only voters. I have no idea what to do in that case. This one's a weird one. I didn't think they granted, but they did, and I have no idea what's going to happen. So
But if you're taking, when you're down to the state level, even though each state should decide for itself.
it's
So
a
when
weird
you have the
question.
concept of what happened with the accommodation in the creation of the country to allow a different count for African Americans, and that you're getting, are they citizens or were they brought over here involuntarily?
Right, so the 14th Amendment basically says all persons,
That's right.
but the Reynolds v. Simpson, which is one person, one vote, it's based on the voters, so it's a weird case. I don't make any predictions on this one.
You don't know if you have any.
And state senate apportionment is held to a different standard.
Yes, it's the U.S. Senate. California has 2 senators, Wyoming has 2 senators. So the representation of Californians is much diluted compared to the representation of some of Wyoming, whereas state senate has to be apportioned equally.
A question about Clarence Thomas, because as you're going through this sort of, learning the lessons of the past, and I don't know how much you know about how Clarence Thomas happened, but he actually seems, the Anita Hill thing was kind of tacked on. Like, apart from that, he actually would have been the self-candidate, right? None of these were on the paper trail.
No, so Clarence actually had given speeches at Cato in the 80s.
Okay.
There's actually this, if you ask Roger Plon about it, he'll tell you about it at great length, but Thomas had written about natural law.
But that wasn't what.
Bush may not have known about it, but people at Cato knew, right?
Okay.
He gave speeches at Cato on natural law and constitutional law. So he wasn't quite stealth, and he didn't try to be.
Right.
He read Ayn Rand.
Oh, yeah.
So he did have a record. He wasn't like a David Souter who had been sitting in his mother's house. David Souter lived with his mother. I think until she was quite old. And Souter was an interesting dude. He refused to use a computer until the very end. He kept using longhand and the typewriter. And his lunch every day, if you don't know this, was an apple and a cup of yogurt. He ate the same thing every day. He would eat the entire apple, core and all. He hated Washington, D.C. He got out of there as quickly as he could and went right back to his beloved New Hampshire. Another funny anecdote. After the decision of Kelo v. Skidley, London, the town tried to seize his house and turn it into an eminent domain museum. It didn't. I think they have much more usage of his home as a museum than. Yeah.
Not so much a question as a comment in defense of poor old New Jersey. Just remember that Scalia was born here too.
He was, that's right. He was, and he
I
left.
may have grown up in New Jersey. I
Uh,
don't want to go that far, but he
you know,
was
I mean,
born
there-
here. So
there
it's
are-
not just brain.
There are justices from 4 boroughs. There's no justice from Staten Island, so I will gladly fill the role. John Stewart did a bit about this years ago. Yeah,
Actually, on your, let the vacancy sit point, I don't know how closely you follow New Jersey court stuff.
yeah.
Do you know we have 2 vacancies?
How long have they been there?
What is it? How many years? Basically since Christie,
So rather than fill it poorly, he just left them empty.
yes, no, they have temporarily cuff. Well, I guess is it just one?
You're talking
They
about,
had 2 for a while.
They had 2 for a long time.
what's
So
her
I guess
name? I
Solomon
forget the-
filled 1, and then Cuff is just placeholding.
I thought they had actually went to 2.
Nope.
But I
Cuff
know
is.
you got Richards and Patterson. And Patterson.
And Patterson, yeah, so what happened was, it was kind of bungled from the start. There was an opportunity, the way it works, you get, is it a 7-year? It's a 7-year,
7 years.
7 years, and then
and
you're
then-
renominated and reconfirmed for lifetime until mandatory retirement at age 70.
age 70 right now.
Right. So there was a sitting Supreme Court justice who was 68 years old.
Oh man, just let him retire.
And he didn't. He declined to renominate him, and everything blew up. He was also the first African American and a buddy of the Senate presidents. And so then after that, there was just this sort of standoff. And the outcome was he got Ann Patterson, he got Solomon, which is, I don't know what you can say about Solomon.
What about
Well, the
another?
Senate refused to allow any Christie nominees to fill the seat of the justice that he refused to renominate until he would have been.
Until he would have been, right.
70, which that has now come and gone, that
Right,
period.
and
but
that
so
was
it
when Ann
2
Patterson
years.
got, so that was vacant for 2 years, and then Ann Patterson got his
Yeah,
eventually,
they
right,
refused to consider anybody
right,
to be appointed for that seat.
right. And then there was just a multi-year standoff.
I think if Justice Kennedy, something happens and we walk us down, I don't think it'll be clean. I don't think it'll be a single nomination. And I think Republicans need to have in their back pocket saying, okay, well, if we win the Senate next go around.
Well, and that's where I think actually, I mean, as frustrating as it's been to watch this, I actually think New Jersey is, you know, for what you're talking about, could be kind of a model for that.
Is New Jersey better off for Christie not budging, do you think?
No,
Well, no, because we got these
Well, no, it
temporary
wasn't,
justices.
no, it was not Christie not budgeting, believe me, it was the Senate president not budgeting.
no, well, the Senate president what he puts in print is not really what was happening. They want to still make sure that they can get control of that judiciary, and under our state constitution, the Chief Justice appoints all appellate division judges. So he's got
Wow.
the Chief Justice in the Constitution
What a
appoints.
horrible decision.
Wait a minute, appoints all appellate division judges, which will come from the Superior Court, and appoints all assignment district judges. So the Chief Justice has complete control, as he does when they reapportion the districts, because if the R's and the D's don't get together, even though combined together, the I's actually outvote the R's and the D's, but they're cutting up the pie. The person that the Chief Justice appointed was on the conference was a person who believes legislators should be reelected, who have a lot of knowledge. He wants to protect people who have been in office for a long period of time, which is why we are shafted. Long story short, which I'd rather work with you later on 2 bills, because I've been working for about 12 years. I'm close to the votes. It's the behind the scenes stuff where we will not give you a Supreme Court justice lifetime tenure. So I got to draw it in such a way that I can get rid of this kind gentleman who will be there like forever.
Yeah, so Christie.
As to allow them, every justice on the Supreme Court will get 5 years instead of 7. Then you get reappointed and reappointed until age 75. That's the lollipop. But I want to take away the ability of the Chief Justice to appoint. Now, this is strategy that stays in this room. The guy that's the Senate president right now thinks he's going to become the governor. So he would like to have the ability to appoint all of the appellate division judges. It's political pawns. We have a very bad judiciary. They do legislate from the bench and all that stuff. So you got to do a lot of behind the scenes stuff if we can do a little bit. But this gets to that California case because the powerful unions, the teachers union, there's 2 ways to take them down. And we need a better RFRA in this state, which is what I'd like to have some help on in drafting.
So they renominated the existing sitting Chief Justice. Christie got his friend Solomon on the court, and then there's one that just remains vacant, and it's not because Christie was holding out as much as it was because the Senate president wants to be able to fill it when he takes over.
Right.
So, you know, but the thing is, you know, we always thought there has to be some sort of pressure. Surely they can't just let these vacancies sit vacant for all this time, but this is what they did. They temporarily, without really any legal authority, they temporarily elevated appellate division judges
Was
to
it the most senior?
temporarily.
It was the most senior assignment judge.
Yeah, exactly. Just, but there was no authority to do that.
Yeah,
They
Radcliffe
just
said
did it.
earlier.
Yeah, I mean, they just did it, and so that you had what appeared to be a full working Supreme Court,
Yeah,
but just with like,
big judges.
with fake judges, yeah, no, that's exactly
Say
right.
we reached a point, you know.
Lena, I think it's murky language in our Constitution about the ability to make that replacement. It's never really been tested
Right.
correctly.
Question.
Could I give you one little thought, if you don't mind me pushing? What, I call it Bush 1. What if Bush 1 had picked Jack Kemp as his VP? What a difference the world would have made.
Really different.
He would have pushed, he would not have allowed Sunu to get away with it, and that was the key. And if you want to know the background story, because I was in New Orleans with Henry and Peggy Noonan and whatnot, and Bush 1 said, I don't need a co-president. That was the line.
Yeah, one term, I guess, so we have.
Do you have any other thoughts on the Harriet Myers? I mean, because that was just so much fun. You know, remember? It was.
Presidents can't, no more personal favors, right? And this doesn't just extend to the president. It can't just be the friends of those in the White House. A lot of people, White said, oh, we know John Roberts, he's one of us. He was a White House counsel, we worked in the Rating Justice Department. We know him, he's one of our people. No more.
And this was something from Governor Christie, apparently. He was, he himself had this question, and I think that was why he liked Sullivan so much, was this idea this idea that he was someone that he knew, and isn't that arguably more instructive for how they're going to behave in the world than this sort of fancy pants little structure business?
No,
Sorry, I'm loving.
I don't think these personal friendships, everyone knew John Roberts. He never once said we thought about affirmative action. He never once said we thought about separation of powers. He's always trying to avoid the issue. That's why Watson was given his speech on constitutional and speech on the theory of the Constitution, showing me the thought of these issues, not just the issue du jour as a client, but what the big picture is.
And I guess my last question for you is, so much of this, I mean, the Harriet Myers nomination, I think, setting that one aside, so much of this is just the product of staffing, it seems like, right?
Yeah, and I mean, the Bush administration had good staffing, but then Harriet Myers was inexplicable.
Well, that was.
Because effectively what happened was, if you read Jan Crawford's book, Bush asked Harriet Myers' subordinate to vet Harriet Myers.
Yeah.
Basically, Harriet Myers' subordinate was vetting her. There was a systematic breakdown of the process that led to this. The circuit court judges they did good on, but the Supreme Court not so much. Thank you all so much. Really
All right, everybody, November convention. You know, we're not gonna schedule something for the month of November because it should be in DC.
You should go. I'll be there.
It's,
All the cool kids are there.
thank you, that's exactly right. It is completely
We-
true. And if you're
November
gonna
Boys
be there,
Convention.
let me know because we typically do a dinner, like the New Jersey crowd gets together for
Where?
a dinner.
Washington, D.C.
Friday night.
The Mayflower.
So. Mayflower, yeah, and it's just, Richard Epstein will undoubtedly be on panel.
He's always there.
He's always
They can't get
there.
rid of him.
No, exactly. It's always fun. You know, if you're really lucky, he'll pick a fight with, Chai Feldblum, and it's just, it's a lot of fun. And yeah, so that's going to be November. December, I'm a little bit up on the air. Sometimes it's just difficult to schedule things in the month of December because we've got, parties and just getting the venue itself turns out to be a scheduling challenge. So it is possible that this will be it until January, and then we'll have like a whole new line of speakers. So thank you guys. I think one thing I'm encouraged by is it seems like, because I feel like the justices are kind of a product largely of staffing, and it seems like you guys getting this out there early, and I think the reception has been really
Hope so.
pretty positive. You are, you're speaking to the right people, and no matter who they are, they'll basically be drawn from sort of the usual suspects, and
I hope so.
right?
Hope we get this one right. Well, thank you all so much. Appreciate it.
All right.
Thank you so much.